First of all, good morning, everyone. I'm very excited to welcome you to this wonderful webinar on legal updates. Florida Statute 718, very important. We're not talking about HOA land today. We will talk about condominiums and what they mean for your community. Very important topics that will continue to evolve. So again, you have to know what's going on in condominiums with these legal updates. I am especially proud to be joined today, and I'm very excited to be joined with my incredible professional colleague, Jessica Ruiz. Welcome, Jess.
Thank you.
And yes, and our wonderful attorney Jane Bolin, an experienced attorney, trusted voice in all the communities, and we do a lot of business with Jane. So I'm very, very thrilled to have you both here. So without further notice, we'll jump in. Jessica, if you want to introduce yourself.
Yes, thank you, Maureen. So my name is Jessica Ruiz, Senior Vice President of Management with AKAM, and I've been now in the property management industry for a little over 20 years. And yes, I'm very happy to be joining Maureen, of course, and Jane here to go over a lot of, or a few of the more common practices that we use on a day-to-day when it comes to these recent changes in the statute. So with that said, I will now pass it over to Jane.
Thanks so much. I appreciate the opportunity to be here. Thank you very much for taking the time out right before lunch to really dive into the statute. So HB 913 was passed, and there is a lot in that particular bill, only impacting condominiums and cooperatives this year. So if you're from an HOA, you're welcome to listen for maybe what we call coming attractions to the changes in your statute. But this is about 718 in Florida condominiums today. So I am the owner and founder of PeytonBolin, which is a real estate and association law firm. And the reason I was so excited to do this is I was a manager before I became an attorney. So I owned a property management company. I could have worked for AKAM had AKAM been around when I was actually AKAM. But what I like to do is say, let's dive into the actual practical application of the changes. So today we're not going to talk about everything that happened in HB 913. This is not a formal legal update. This is really, we've picked 3 areas that we feel are what board members really need to understand now. And certainly we can open it up to questions, but if you could keep your Q&A to what we're talking about for the time being, that'd be great. And then we can dive in if we have time at the end, and I'll do my very best to answer other questions for you. So thanks again. I'm going to go ahead and click into our webinar logistics. So there's no credits for this. This is not for board certification. This is not for community association managers. This is for board members to learn and grow. We'd like you to use the Q&A function for your questions. And remember, this is an overview, not a comprehensive guide. However, we are going to talk about how you practically apply this day to day. And I always have to say this because I am an attorney. This does not create an attorney-client relationship between you and I. If you are my client, please reach out to me afterwards. We can certainly talk about anything that you've heard. And I would encourage all of the board members on here not to take any action until you actually speak to your attorney. There are always nuances to the law. Something that comes to mind is Kaufman language, which is whether your declaration of condominium is subject to the changes of 718. For the most part, most are. However, there are exceptions. So that being said, we're going to go ahead and get started. Okay. Virtual meeting options and video meeting requirements. So when I saw this change being developed over the last 6 months, I was quite surprised because I think we have all come out of a time of, sort of post-COVID, right? During COVID, everybody switched to Zoom meetings and nobody said a word. And that was totally fine. We were for all intents and purposes, under a state of emergency. However, now that we've come out of that and have habituated ourselves to online meetings, we have a couple wrenches that have been thrown at us from the legislature that's going to change how that's done. So the first news is that all meetings, board meetings, unit owner meetings, including annual meetings, committee meetings, can be conducted by video conference. So the first thing is HB 913 says, hey, we've caught up with the times. You can absolutely do a video conference. fantastic. Now, on the right side of this slide, you're going to see, and I have two screens, so I apologize if I'm looking other spaces. You're going to see that we've defined video conference as real-time audio and video meeting between two or more people in different locations using video-enabled and audio-enabled devices. So they've given us a definition for it. And for any meeting conducted by video conference, your notice of the meeting has to include a hyperlink to join that meeting as well as a conference call-in number. And you must have a physical location where unit owners can attend. So just pause. You're having a video conference meeting. You also have to have a physical location for owners to attend. And you should have on that notice a statement that the meeting will be recorded and kept as part of the official records. So those 2 points there, 2 and 3, I just want to stop at. So video conference is no longer just video conference. It's a hybrid. I would actually call it a hybrid meeting. So from the AKAM perspective, I'd love either one of you to tell me, really, how are you guys approaching this? And are you providing them locations? What is that looking like for you?
So obviously, because we've kind of stayed on the Zoom participation of board meetings since even after COVID, just because we get more participation from the community, more involvement with those residents that are not able to attend in-person meetings. We have a little bit of practice, right? I think what's new for us now is that they have to be recorded and they have to be published. And so I've never been a fan of my boards or associations regarding Zoom meetings. And so now I think for that reason, if I have a board that wants to continue having Zoom meetings with the video option, it's important for all of us to be prepared. I'll have my manager create a script, not only for themselves, but also for board members to make sure that we stay, in line with what the agenda topics are. We will obviously have a management team in person providing access to a room as if we had an in-person board meeting, even if the board's going to be on Zoom, so that people can attend in person. And I think now the key is we always have to be and be expected to be prepared for board meetings, but I think, again, if we know they're going to be recorded, we have to be that much more prepared.
It definitely changes the landscape. So let me take everybody back for a second. So let's just call it regular meetings of the board have always been able to be recorded by a unit owner that's there. I mean, I've answered this question 1,000 times. Can somebody use their iPhone and record my meeting and put it up? Yes, they can. But what changes that is that's a unit owner recording it, and that's their record of it. Okay. What changes here is if the association is doing a video conference, it's required to be recorded, as we said, and it is an official record. So it has to be put into, and we're going to talk more about official records as one of our three areas. So just notice it has to be recorded, and now it is a document. So I would also share, and if people have heard me talk before, I don't like a transcript as meeting minutes, and I don't like a recording of a meeting like this because everybody says more than maybe they should. And that's coming from my risk perspective as an attorney. So I think it's great, but again, physical location, you must have it. You cannot just have all online. So in your minds, I'd like you to think of it as hybrid, and 2, know it's being recorded. And you really do need to put that statement on there so people understand that they are being recorded, and it will be part of the official record and can be pulled at any time. But this also gives me pause. So let's talk about the 2 times that you can actually close a board meeting, right? So board meetings are open and transparent, available to unit owners. They can speak on agenda items. We have, proper notice 48 hours in advance. But we can close a board meeting in 2 instances. 1, to discuss personnel, AKA your management, right? You can close the meeting and say, unit owners are not invited to attend. We're discussing personnel. And 2, with your attorney to discuss proposed or pending litigation. There's no carve out under this video conference for that second one, which is proposed or pending litigation. And there isn't a carve out for the first one either. So why do they have closed meetings? Because they thought, well, this is a sensitive topic. Who our management company is, who our personnel is on site. And now it has to be recorded and is part of your official records. So keep that in mind. So, and then the second part is with attorneys. I mean, I'll let you know right now, our firm will not participate in a Zoom hybrid closed meeting with an attorney because it will be recorded and our attorney-client privilege is gone. Ultimately the holder of the privilege is always the client and they can give it away if they want to, but we're having some detailed discussions about strategic strategy when it comes to specific collections or cases, etc., or unit owners that are tough to deal with. I mean, sometimes what we're talking about is just human relations. We don't want that out, in the world. So we're not going to have hybrid video conference meetings, and that's unfortunate because it saves time and money for everybody. I would tell you that's just the thing you need to think about, right? It's a totally different perspective. And I would also tell you that the bill drafting has already begun for the next round of condo fixes. And certainly this has been a discussion because it's not just me. All of my colleagues, the excellent association attorneys that are in Florida have said, this doesn't work. Why? It doesn't deal with closed meetings. So from that perspective, I just said a lot. You guys, any thoughts on that? Or
Yeah,
are you feeling like, whoa?
I was actually surprised to see that even the closed meeting had to be recorded. So I was like,
Yes.
okay, I can understand why that may be revisited in the
Yes.
near future. So, but I do have a question, Jane.
Sure.
Because we've also been kind of, I mean, obviously we facilitate Zoom options, Teams options for our boards and managers to use, but what if they disable the video and only use an audio for people to
Coming attractions, Jessica. I wish I had the answer to everything. So if they disable the video and they just do the audio, at this point, this is what I know. Let me tell you what's true. The division has the right, so Division of Condominiums, Timeshares, and Mobile Homes, to promulgate rules around this. So I think that's where we're going to see this nuance about, well, must they both be enabled? What if it's only one? Because now we're just talking about a conference call. But if you do a conference call on a Teams or Zoom platform, you can record it. Whereas, sometimes you can just have a conference call and it's not recorded. So I think I don't have an answer for you. I mean, I'm just being honest, right? This is black and white from the statute. We are all in the business of figuring out the interpretation of it. I would tell you right now, when this tells me video conference is defined as real-time audio and video, I'm going to tell you the and is a must. So it's both audio and video. I don't think you can gamify it. That would be my general response. But again, DBPR is going to promulgate some rules for us. And that's probably going to come out, I imagine, after November. So, but good question. Hey, let's go over to the other side on the annual meeting and budget, and then let's look at the Q&A and see if we have any questions on that.
Sure.
So, major change though, hybrid meetings. Want to make sure physical location, and it has to be a part of the official records. Next part, annual meetings. Now, this is a real stunner too. So annual meetings, they used to have to be held within 45 miles of your community or in your county. Now it is 15 miles. So the legislature made that smaller, which is a great thing because 45 miles could take me all the way, close to Homestead from Fort Lauderdale. So that's just the reality. So that's been changed. So your annual meeting must be within 15 miles or in the same county as your community. And the annual meeting may be held by video conference. Okay, great. But let's pause for a second. The annual meeting is a meeting of the members. Board meeting is a meeting of the board. Annual meeting is a meeting of the members. Generally, the election takes place there. It's an owner's meeting. But the statute has changed to include that a quorum of board members must be physically present if an annual meeting is conducted via video conference. Physically present. Physically present. I know my colleagues are also like, that's not their meeting. Why do they have to be there? We don't need a quorum of the board. Doesn't make any sense. So this is another sort of head scratcher, and I would say is probably a response by the legislature to the small group of people that they hear from. And if you're on this webinar, I would hope that perhaps you would say, that's something I should rip an email to my representative about because it doesn't make a lot of sense. But right now it's the law. So you can't have a video conference annual meeting unless you have a physical presence of board members there. That constitutes a quorum. Totally wild, isn't that?
Yeah.
Absolutely.
Yeah.
Absolutely, because annual meetings are held typically the third or the fourth quarter, where, board members tend to, they might be going to see family members or whatnot, and
Sure.
they're not present. So I think it's interesting that they went ahead and added that. Very interesting.
Sure. Because before you could have had an annual meeting, an election, have the CAM run it. I mean, just, you need a quorum for the annual meeting if business is going to be conducted. But as we all know, you do not need a quorum for an election. You need 20% of your eligible votes to be cast. So it's very interesting that they made this, and I think we will see it cleaned up, hopefully.
No,
Um,
and it's because it says a quorum, because in the past, you'll see typically the president will stay and they'll open up a meeting or whatnot, but quorum is very different.
very
Yeah.
different.
And a lot of condos really don't have annual meetings. I mean,
They have their election, but they don't actually conduct other business. I would agree with you. I would absolutely agree with you on
Yeah.
that point, for sure,
That's the
Jessica.
fastest meeting, a minute.
Yes. Okay, so now here's another interesting part, and I think it's interesting. So budget meetings may also be held by video conference. Great. But the video conference budget meetings, this is the only place this language is there, must allow all discussions to be heard by board members, committee members, and unit owners physically present. So it's just a little bit of a disconnect that they didn't, I don't know, put that in every place that they said a video conference could be. And that may be where the DBPR rulemaking authority picks up and says this applies to all, video meetings. Because think about it, you have a video conference meeting and you just have like an iPad with a very low volume and no way to project it. People can't really hear what's happening. I've personally have attended many meetings where I'm like, I cannot hear you. But it's interesting. In the budget context, though, it's very, very clear. Okay. So I'm gonna move on.
Jane, let me
Yes.
ask you a question. Would it be usable to go ahead and like Jess said in the beginning, have a script? Obviously, the discussion is a discussion once you open it up, but wouldn't it be recommended to have a script, especially with, when talking about budget meetings or important decision making? It's always best, or have maybe a policy and work with the attorney, the association legal counsel to do a policy, because the discussion could last for an hour if you want to have a discussion, right?
Sure.
Conduct business. So what do you think will be best to work with the attorney?
So a couple things. I think
Policy.
one, you can always pass rules and regulation as to the frequency, manner, and duration of statements at meetings by owners. So that's always been in case that I think that's the first thing. I think in light of what we're talking about right now, a script, I think a script is maybe in my mind is just more an embellished agenda. What I would like to see is some training that board members understand that we're sticking to the topic that we're speaking about, and we want to limit, unfortunately, this actually makes me want to limit discussions versus having every thought that you have about a vendor out in the world. So I think board members need to be trained about the fact that they're being recorded. And I like the idea of the script as a more intense agenda that makes it really clear how we're moving through. I think that's a good idea for sure. And here's the other thing I'd say from a management perspective, whether it's AKAM or somebody's with somebody else, you should in advance, if you're going to go down the road of having what I'm going to call hybrid meetings at this point, because of the physical location that you have to have, I think you should really determine what is your technology. And do you have the right technology? Do you have the microphones? Do you have the audio speakers? Do you have the laptop that's dedicated to it? I think all of those things are things that need to be thought about in advance.
yes, and tested way before
Yes, 100%.
the actual meeting.
100%. Okay. One side note that's not in this presentation that I'm just going to bring up around the budget meeting is there is a change in the budget in 718 this year that allows unit owners to vote on something called a substitute budget. And if that takes place and you're having a virtual meeting, I can definitely understand why they put in this specific language about everyone being heard. A substitute budget basically is a secondary budget that removes your insurance, your SERS reserves, and any other mandatory reserve that you have from the analysis, and requires that you remove discretionary expenses and give another alternate to the owners to vote on. So we could do a second HB 913 deep dive just on that, but just putting that all together, I think that's why they put this language in here that way. Okay, I'm going to move us on. So now let's talk about another area where the legislature just went wild, in my opinion. And bless the legislature, we appreciate that they do what they do, but this is definitely an area where I was surprised. So electronic voting versus manual voting changes is how I put this, because I want you to think about it from this perspective. In a condominium, okay, in a condominium, we all know the election process. Every condominium is subject to the same election process. 60 days in advance, you send the first notice, 40 days, notice of intent to run, 8.5 by 11 candidate information sheets at 35 days, 34 to 14 days, you have to send out your second notice and you have your election, right? What happened a couple of years ago is that we created online voting, like the option to actually vote online, electronic voting. So great, wonderful. It has absolutely been a decision of the board to do that. Okay. And why has that been a decision of the board? Because it costs money. You're going to use a third-party vendor to do your electronic voting. There's no way you can create a system that's going to meet your statutory requirements on your own. Like, just not going to happen. Okay. So you use a third-party vendor. And one of the things I said to boards as they were considering this is understand, once you adopt by resolution electronic voting, you can't go back. Once you adopt it and you give somebody the right to vote that way, they have the right to vote that way. You cannot take that back. Now, it's a trend that we're all living through, right? Everything is becoming online. Everything is electronic. It makes perfect sense. I think we're part of that trend right now. But what changed here is the first thing on the left. So unit owners can now actually submit a written petition. If 25% of them get together and they can say, you know what, for our next election, we're requesting electronic voting. The board has to consider and adopt that within 21 days. That's not adopt it. They must adopt it. And the petition has to be received at least 180 days before the annual meeting, which is fair, right? Because it takes time to find a vendor and get them set up. But understand what has just happened is a right of the board has now been taken away, and they've given the owner the right to force the board to do that. I think I can go either way on this. I can understand the reasoning behind it, but it is, I think, a pretty dramatic change because it is something that's within the, in my opinion, the business judgment of the board about whether it's a good idea to do that for their particular community. So that first change happened. Now, if you say, guess what? No one's ever going to, this is actually teaching this course a couple times in the last month. I've had board members say to me, unit owners are never going to know about this change. And I say, yeah, you're probably right. They're never going to know about the change. Okay. So they're not going to tell their owners. They're not going to make it. They're just going to leave it there. And that's akin to 20% of owners can petition to put something on the board agenda. And that's happened like 10 times in my career. Like, people just don't do it. Okay. So you are now sticking with your regular election. It's the paper, it's the outer envelope, the inner envelope, all the things we just talked about, right? Well, if you're going to do a regular election and you don't have electronic voting, the association must designate an email address specifically for receiving completed electronic ballots. What? Wait a second. Usually I have to put that in the second envelope and my name's not on it and nobody knows how I voted. That's right. They're going to know how you voted because the electronic ballots include fields that include your unit number and your name, which is your electronic signature. And there's a large disclosure that says you have waived your right to secrecy by submitting this ballot. So let me step back. If I was in the state legislature and I heard from owners who said, why can't I just email this in? It's crazy. USPS doesn't work. Mail's always late. I get it. Makes a whole lot of sense. But this really opens up the ability for people, bad actors, to create a lot of fraud in elections. All you have to do is send in a bunch of ballots. And then all of a sudden you got duplicate ballots. Your election monitor is telling you those ballots won't be counted. You've got a mess. Now, again, don't tell the bad actors this, but that's what this opens up. So it's really wild. And then what this does is it requires, now flipping it over to like management, you have to have a sworn affidavit from your association's designated email administrator or your manager that they have done a thorough review of your inbox, your junk box, your spam box, and you are going to swear under penalty of perjury that all of those electronic votes have been properly counted and you've checked it. So it's a really wild twist, and this is, I know I'm being very dramatic, but I think it's a dramatic thing. And you know, a couple other things. This is a new affidavit. We'll talk about that in a little bit. There's a lot more affidavits in the world these days in 718. But from an AKAM perspective, what are you guys going to do? Are you guys going to create a separate email for your boards? How are you guys going to handle this? And who's going to sign that?
Yeah, I feel like this, you have to be dramatic when you're talking about this or thinking about this, because those folks that didn't want to sign up for electronic voting because the perception was that it wasn't safe or secret, now we have this, right? So I think that's going to eliminate that misperception. And what we're really going to do is, we don't have very many associations that are not already on electronic voting, but those that are not, we are going to push heavily.
Yeah. I think now, to me, this does mean like just go to electronic voting and let's move. It's just, I think it was well intentioned, but I don't think they thought about the fallout of what could happen here.
And Jane, I think here what Jess mentions, and you again work with the association, legal counsel. Most of our communities are in electronic voting because we have had to do, you know, huge projects, changes, etc. So everyone just got into the being practical of obtaining the quorum, getting the votes in, right? So the struggle is not as much because most of our communities are already doing it. But I definitely think it's worth it, and at the end you'll save yourself, you know, somewhat of money if you really budget it correctly, right? Because it's
Sure.
we're gonna start we're pushing for more participation online, somewhat less money is gonna come out of it.
Yeah.
So
yeah, your
Perfect.
election meeting, you know, your time dedicated to the election meeting and process reduces significantly. The verification process is easier.
correct.
The whole process of closing it out and counting ballots and wrapping up your election is easier and faster. I mean, I had associations until maybe last year that had 700 plus units, and we were having elections till 2 in the morning.
Oh yeah, it's outrageous.
Right.
There's a lot of pluses.
Yeah.
Yes.
A lot of pluses. Great. So I'm going to just, ladies, I'm going to move over to the Q&A real quick, if you don't mind. I'm just going to take a look.
Go.
Will we provide the presentation to attendees? Yes, I will export this into a PDF and provide it to AKAM, and they'll send it out to everyone who is here. What if a board member attends via telephone audio only? I don't think that's going to be an issue. So I think you've always had the right to attend by telephone. You've counted towards quorum. I don't think that's going to be an issue. How do you record meetings? Yeah, so you can record meetings, any of the platforms, Zoom, Microsoft Teams, these video conferencing platforms all have a recording option. So that's how you would do it. And it's a good question as you start to look at what your vendor software will be. Let's see. Just like to confirm, board meetings must be recorded. These recordings need to be provided to the membership as official records. So Georgia, thanks for jumping in. What we talked about is not all board meetings have to be recorded. So there's two types of board meetings. There's a regular board meeting, which is in person. And now you have this video Zoom option. So you have a video audio option to have a board meeting. That requires that you have a physical location that people can attend. And yes, you must record that if you're doing it on a platform like this one. You must record it. So thanks for asking. Let me keep going. Can questions or subjects of the board meeting be discussed if not on the agenda, and does new business negate that? So Gary, that's a really good question. So the reason that the agenda has to be posted for board meetings is so that unit owners have an idea of what's going to be discussed and they can speak to any agenda item. My preference is not to have just a new business section, is to be specific, but you could, but that really opens a can of worms. And if there's not something on the agenda that really must be discussed that was not put, then I would say there would be a ratification by a supermajority of the board members present to amend the agenda at the beginning of the meeting to add this other discussion item. The reality is this, it only takes 48 hours notice to do a board meeting. So if it's really that important, just put up the next, have another meeting in 2 days. But that's how you would handle it. And definitely speak to your attorney as well, because that is the advice that we give. How does the board have to present a secondary budget for owners to vote on? So the secondary budget that I brought up is called a substitute budget, and that's if your current budget is more than 115% of last year's budget. And how you make that analysis is you remove your mandatory SERS, your insurance deductibles, and your other mandatory reserves, and then you determine if it's more than 115% from the previous year. If it is, you must then create a substitute budget that removes discretionary expenses, and that's directly out of the statute. And I say that with a big smile because I don't know any
What
budgets that
defines
have discretionary expenses. So that's how that works. And it probably would be worth having a conversation just about the financial changes. So I appreciate your question, Sandra, and I hopefully answered it for the time being. Jane, you mentioned the importance of boards being trained to stay on topic during meetings. In your opinion, who is best suited to provide that type of training? Should it be the management company, a third-party professional, or somewhere else? So that's a really good question, Hendrik. I think it is a combination of speaking with your attorney and your manager and creating the training. There's not a lot of third parties out there. There are some folks I know like CAMU that support management and managers. But this kind of training, I really think it's an evolution right now. And as I say this out loud, I'm thinking I should create that kind of training. So thank you for the idea. But right now, I would just say, talk to your attorneys about these changes, talk to your manager and say, like, let's get together. How do we train the board on this? And that's a very different perspective than just, providing a management report. And I'm quite sure AKAM, do you guys want to speak to that? I imagine you guys would be willing to do that anytime.
Yeah, for sure we will. And then I have a few boards that I've worked with along with my managers to kind of go through the process, especially new board members, right? So when we have a change in boards, we usually hold what we call the board member orientation, and we go through this process with them to have them become familiar with.
Great. That's perfect. So you can add that to board member onboarding. I love that. It's wonderful. Sandra, your question, what is the word resolution in the electronic voting section? So the way originally electronic voting was created is there's a very specific resolution that must be passed. And a resolution is essentially, it's like taking a motion and giving it a lot of depth, and it's a written document. And so that's the resolution that they're talking about, is that the board must pass it by resolution. So that is part of the official records and not just a vote that's documented in the meeting minutes. I think that's probably the best distinction. So it's an actual document that gets passed. Yes, you will definitely receive slides after the presentation. I will export this and send it over to AKAM.
Yes, and the recording too.
Yeah,
We'll have
and we have
recorded, so
we're recording it too. Perfect. Okay. Is the electronic voting email required if your association currently uses a third party for annual election? So I'm assuming you mean like someone else, a third party is, well, that could mean a lot of things, Kirsten. So I'm going to do my best. It could mean that you're using a third party to run your meeting, like having an election monitor or having an actual election company come in. The distinction here is if you're not, if you're not doing electronic voting online and there's a written paper ballot option, then you have to have this email. That's the best way to think about it. I think that answers it. Are there any restrictions on the number of meetings a board member can attend virtually? No, there's not. There's not in the statute. I definitely think you should check your governing documents, but the reality is most of them don't address this. So I think you'll be fine. And third party for electronic voting. Yeah, so your third party, thank you, Kirsten, for jumping in. So if you're using a company like Get Quorum or ONR, they may jump in and provide you an email to accept those electronic ballots. That would be a change in what they're currently doing. I haven't seen it, and I think it's only July 29th. This became effective 28 days ago. I don't know if they're going to give you that option. The way the statute reads is that there has to be an affidavit from your email administrator, which you could delegate out to your third party or your CAM. So I can see that being the case, but I don't know if they actually can give you that option. I'm just not aware. All really good questions. Thank you so much. Oh, one more, and then I'm gonna keep going. 25% of the voting interest written petition for electronic voting. Can this be changed by a vote of the board without a petition of voting interest? Oh, yeah. So thank you, anonymous attendee. So first of all, the board can already choose to do electronic voting, and there's a specific process which includes them passing a resolution at a meeting to do so, and then giving owners the ability to opt in. This change basically means that owners have the ability to force the board to do it, is what this means. Okay,
Jane,
great.
also, talking about electronic vote, the process, right? In the past, there was a small little change too about the notice that it had to be 14 days and now it's normal,
Yeah.
right? So maybe, I think we haven't mentioned that. It's just good to know.
Oh, yeah, thank you very much. Yeah, I
Okay.
picked the highlights of things that I thought, having taught so many of these courses, these are the practical application bits where I think board members need to be like, all right, I understand it from this perspective. Again, the highlight is it's not all of it. So perfect. Okay, let us move into record keeping requirements and website changes. This should be, and this is our third component, or else we'd be here for hours. But first of all, I'm going to pause. Official records. Official records are the ability of a unit owner to actually see the records of the association. A condominium is a not-for-profit association. It is meant to be entirely transparent. So owners have had the right to inspect records, and that right has been changing, like the nuances of it over time. But I think one of the most important things is that you don't discount official records. So one of the things I hear to this day is, why are people asking for records? It doesn't matter. Anyone can ask for a record if they're a member of the association. They have a right to inspect it. They have a right to copy it. And there's a list of what are official records that is extensively long. And there's been two major changes to that list that I'm going to talk about. But what I want you to know is there's one kitchen sink provision, which says like any record that's created, based on the business of the association. Those are my words, but that's really what it means. So official records really need to be taken seriously. And in our third slide here, I'll jump to why. And I definitely want to get AKAM's input, but let me tell you the first two big changes, and then we'll take it from there. So always listed was you had to have a book of meeting minutes, which is an old school way of thinking back when they had books of meeting minutes, right? But they're basically saying you have to have all the meeting minutes of the association, the board of administration, and the unit owner meetings in your official records. Makes perfect sense, right? So now what they're saying is that needs to include a recording of all the video conference, which we've already said before, but you must have the minutes of all the video conference, and you have to have the video conference in your official records. That has to be maintained for at least a year. So the video itself is only 1 year, but most official records are 7 years. And I'll show you a quick chart on that in a second. And then the next change, oops, let me get here, sorry. Uh-oh, my slide just paused. Give me 1 second. I'm going to stop my share. Let me just reopen this. Let me just exit and reopen. My apologies. Technology. Let's try one more time. Give me a second. Okay, let me share one more time. Sorry, I had to go back to the beginning, but I will bump ahead. Okay, so let me go back here. There we go. All right, we're back. Okay, the second change. You've always had to have accurate, on the left is what you've had to have, and the change is on the right. So you've always had to have accurate, itemized, detailed records of all of your receipts and expenditures, but now includes bank statements and ledgers. So let me just pause there for a second. This is the bank statements of the association and the ledgers of the association. It's part of the official records, notably not on the website side as an update. And one of the things I'd love to know from AKAM is, how are you guys going to handle when people ask for bank statements? How are you guys going to handle that as a management company?
So typically our financial statements include copies of bank statements for every bank account that the association has opened.
Great. Well, it's the best practice without a doubt. But they just made it much more specific. And I think the one practical pointer that I really want to point out is if you're going to give bank statements, just redact your account numbers. We live in South Florida. There is a litany of fraud here. So don't give any bad actors any sensitive information, and you have the ability to redact that. No problem. Good stuff. Okay. So let's talk about the whole thing. Owner information protection is important. And you have to maintain a roster of all current unit owners, right? That's an important thing. In fact, it's something I think you should be looking at well before your elections as well. And that includes mailing addresses and unit identification numbers, voting certifications, like the certificates of voting, and telephone numbers if they're known, and email addresses and fax numbers with consent. With consent, meaning they've agreed to electronic notice. I think the most important thing is that these items can only be used for the purpose of association business. The association cannot sell them to third parties. That was a change last year in the law, which was a good thing. Should be redacted before documents are shared with non-owners, meaning if there's sensitive information in there, they haven't had the right, they don't do electronic notice, then you can't just give out their email addresses. If they have consented to electronic notice, then you can give out their email addresses.
I have a question, Jane.
Yeah.
Now that you mentioned that. So because I've seen some resolutions worded a little differently, or some consent forms for unit owners rather. Some of them give the unit owners the option of consenting to electronic notice and online voting. Some of them both. So if a unit owner enrolls in online voting, does that automatically give the association consent?
I do not believe so. I think they have to agree to consent to email to electronic notice to give them that address. I wouldn't be surprised if other attorneys had a different opinion because we split hairs on these things, but I think electronic voting is separate. I think you have a right to get a list of the unit owners, the roster, but the roster doesn't necessarily include your email address because you're electronic voting. I think you actually have to consent to that, in my opinion.
Thank you.
So I think what's key here about official records, and I said it in the beginning, when clients get official records, one, it's an official records request. If it's in writing, it's an email. If they send you a text, don't discount it. You need to let your CAM know, you need to let your association attorney know. Just in case there are records that you feel shouldn't be disclosed, there are attorney-client privilege documents, social security numbers, medical information in sales applications that cannot be disclosed. But most importantly, there is this new on the bottom here under the red is the new checklist requirement that came through last year. And it's actually quite useful because I think it was a best practice of CAMs in the past, but you have to provide a checklist of all the records that you made available and the ones that you don't make available. And all of that matters because you only have 10 days to respond to an inspection request. And that checklist has to be kept for 7 years. And it's a good thing because it creates what's called a rebuttable presumption that you've actually complied. But then also I added this last bullet point because last year this was added into the statute around official records. You have a good faith obligation to obtain and recover the records. So no longer can you say, oh, we don't have that. Well, what do you mean you don't have it? You don't have our tax returns? You certainly can get those as a public records request. You don't have bank statements? I don't care that management company changed. We had a bank and banks have bank statements, right? So you have this whole area has really changed where it's always had the penalty after the 10th day. On the 11th day, the association can incur a fine of $50 per day up to 10 days, which is $500. The joke on that is it's not recoverable unless somebody actually sues you. It's not something you can just like minus 50 on your assessments. But it has gotten more and more important. And I think it's been sort of a lightning rod for the legislature. They want everything to be more transparent because all they're hearing is that associations aren't transparent. They're hearing from a small minority and assuming it is the majority. Also, because of that kitchen sink provision I told you about, it really, official records creates a lot of work for CAMs and for attorneys. At the same time, it gets weaponized by unit owners who just want to make things difficult. And it's right now we've seen the legislature sort of shift to the side of it must be so transparent that we're going to tell you that it could be a second degree misdemeanor if you fail to produce records. And what they changed this year is what's in red. So it used to say a director or member of the board or a CAM who knowingly, willfully, and repeatedly failed to provide the records could be subject to the second degree misdemeanor. They got rid of the word repeatedly and they put in or intentionally. So there's really not a lot of room for mistakes here when it comes to official records. They need to be taken seriously. You need to respond. And just one more time as an overview, you get the official records request on the next business day is when you start counting the 10 days. And it's 10 business/working days to respond with a date and time or an actual links to the website where it's already exists or copies of the records. So I think CAI is doing a lot of work. The Community Association Institute, Michael Bender, one of my colleagues with K Bender, has been really active in trying to get some of these things tied up for us. But I think bottom line is, the legislature has continued to put in these criminal sanctions in a civil setting against volunteer board members. So this is one place you got to be really, really careful. And if you've never heard of this checklist because it was new last year, you need to know about it because it is in fact itself an official record. So from the AKAM perspective, how are you guys handling official records?
So this is something, especially within those communities that have that very vocal minority.
Yes.
They're constantly doing official records requests, etc. I think what's been really critical for us is to make sure that there's ongoing training from a management perspective, right? Managers understand when they receive a records request, they have to acknowledge it immediately, communicate with their oversights. Depending on the level of the request, speak to association counsel as well. Especially because of these changes, we want to make sure that we're responding accordingly
Yeah.
to this request. We also want to understand what can be withheld. And, that's, I think, part of the important part of this process. But usually, when in doubt, always contact legal counsel. And also, I know sometimes we have board members that are not comfortable with providing certain information. And I think that's when we really need to lean on our experts to walk boards and us through this process, right?
Yeah. I think the key is it's something that has to be taken very, very seriously. And I say in my board certification courses, mostly we delegate this duty to management companies, but I would be very careful because now we know that board members can be personally liable for the failure of it to happen. So saying that, it certainly wouldn't be AKAM, but some other management company didn't do it would not be a cover. Let me just put it that way. So I have this nifty slide. I'm just going to flip through it real quick so you can see. The requirements talk about, permanent records that have always had to be there. 7-year retention, which includes the rosters, the insurance policies. You'll notice the inspection checklist, the board certifications. The 1-year retention on official records, the video conference recordings, and if minutes exist, which they should. Ballots, all of your election information and your bids, and then your 15-year retention is around the SIRS work. So again, this will be in the slide and it might be very useful for you. But let's shift into our last discussion because it moves, when I think about official records, I see, they overlap because really the reality is websites have become your document retention policy in condominiums. And the best way is to have them all on there. However, bank statements and ledgers, if they're not redacted, there's some things to contemplate. It could be something you don't want to put up unless requested, right? So just being very clear about that. So right now, the current law is that if you have 150 units or more, you're required to maintain a website or a mobile application, meaning literally like a mobile app that people could use or a website that they can access. As of January 1st of next year, if you're 25 units or more, you have to have a website or mobile application. So you can see the trend, right? Everything is, we've just talked about it. We're going Zoom meetings to attendance in that
Online.
regard. Yeah, I mean, everything's going this direction where everything is going to be online, which is great. And it's got some hiccups in the language. So let me share with you the last bit. So there are new affidavits. So your websites have to include, just like your official records have to include the affidavits required by the statute, your website must have all of them as well. Now, I put a few here. So one of the changes in this year's HB 913 is that the structural integrity reserve study notice requirement requires that a board member signs an affidavit that owners have been properly notified. That's a SIRS affidavit. Your annual financial report has to be sent out. That actually changed this year too. The timing of it changed to 120 days, and you have to notify owners that they can get a copy of the report, or you send it to them. There's an affidavit for that. Any mailings. And so since when I was a manager 20 plus years ago, when we did mailings, the best practice was to do an affidavit of mailing. So your affidavit of mailing for your elections, for notices for any kind of unit owner meeting. And what does that mean, an affidavit of mailing? It means having an affidavit that says, I swear that the following attached unit owner list was sent the following things on the following day, and here's all of that information, and you sign it again. So I said many, many more, but this is also a trend in condominium law that affidavits are being used to create this rebuttable presumption that you've done it properly. And I think that's a win-win, personally. But note here, for the purposes of what this change was, it has to be on your website. On your website, approved, and the word is approved board meeting minutes for the last 12 months have to be on there. Not in limbo, hasn't been approved yet, approved meeting minutes have to be on there. And then of course your video recordings or hyperlinks, meaning that you've got the recording in a space that's on a server somewhere, has to be on the website as well. And then this is the real kicker. So a document must be on the website or available for download through an application or mobile device within 30 days after the association receives or creates an official record. So to me, this means board members, you should be contemplating what is your policy. Definitely work with your managers. I mean, most of this is always delegated out, but you need to be sure that this isn't like, oh yeah, we didn't have time. Programmer couldn't put it up. That's not going to work. It needs to be on the website. And by the way, the division will definitely have jurisdiction over this as well. So I say that with a big smile because people will file complaints about it. How is AKAM dealing with that from a website perspective?
Again, I mean, a lot of these points have a lot to do with making sure we're putting this information out to our teams, creating SOPs, training, talking about it, and going back and checking on compliance, right? So that's really our primary concern now, is obviously understanding what is required, having a checklist, making sure our managers are going in there and uploading timely what is required and necessary, and continuing the communication and training around it to make sure that we're consistent.
And
Right.
also, for the most part, what we've also done as AKAM is, again, educate our board members, because again, it's a partnership. We work with them and we want to make sure that they understand as well, as if the financials are out, obviously we'll review with the treasurer, but then you have to post it in the website. It's very simple. So again, we want to always work very practical and have the board understand that it's the owner's information. So I think that caveat of educating the board members and working with them and saying, okay, financials are out, we upload them within, the timely manner. Doesn't mean that they're out right away on the 20th and on the 21st, it's Saturday and we're going to be uploading, but within reason, right? But
Yeah, for
absolutely
sure.
to be in compliance. I think that's critical, Jane.
It's
And
a process,
Absolutely.
and getting them to understand that we cannot deviate from this process or else
correct.
is probably, it's good for us, because I know we've all been through times where board members are, I'm not sure that I want that on the website. Well, you no longer have an option.
That's right. That's right. Okay, so I am going to go to our last 9 questions. This timing is perfect. And I was worried that I didn't put enough. I knew that there would be a conversation here. Okay, so our information's available. You can see it there on the slide. Let me go to your questions. So Gary, condo is reduced time. A member can speak from a subject from 3 minutes to 1 minute. Does this meet the demand for transparency? So the board may make rules about the frequency, manner, and duration of your statements at board meetings. The statute now requires that that unit owners can speak 4 times a year on all topics, asking any questions that they want. The reality is that doesn't feel very transparent, Gary, to me. I understand that, but the board can create a rule as to the frequency, manner, and duration of those statements. How soon do bank statements need to be made available to the membership? For example, can I ask for June statements on August 1? Are credit card statements required to be disclosed as well to see a breakdown from spending? So first of all, any statement for any credit card of the association can definitely be asked for. Sure, if you're asking in August 1 for June statements, they may or may not have them. I've actually I just responded to an official records request where I know the record will be available, but it's not yet available. It was a little bit, so I think, use common sense on the timeliness of that. Where must records be provided? Can you resident request electronic records? So that's a great question, Elda. So it really is the right to inspect records, which meant originally that we used to put you in a room and give you a bunch of boxes and say good luck. Now that's changed. We have to facilitate it. We've got to give you a checklist, and we can give you electronic records, but the board can choose not to, and they can absolutely have you come to a location to review them. So it is a bit of a loophole there. Let's see. Some of the associations on property keep their own list of owners' emails so they can send out a notification or information about their individual tower. Is it required to have a consent form? Our office keeps one on file for financials only. So what I'd say to you is those should not be official notices. If you're doing any notices of meetings, any official notice requires that authorization to send it, so and the person signing the affidavit says they've properly given you notice. And the reality is, Sandra, of course you guys have email lists of folks in the building, and if you want to talk about all sorts of other things that are happening, even maybe there's we want somebody to be a vendor and pressure wash the floors, and we're looking for folks. That's not it's not an official notice situation. I'm talking about meetings where owners have to attend any meeting, committee meetings, board meetings, meetings for special assessments. That's where you have to be sure that you've got the written consent. So yeah, I get it. It can be a little confusing because the reality is people just use email lists all the time. Will AKAM have future presentations with Jane covering HOA recap? George, thank you very much. AKAM has lots of good attorneys they work with. I will certainly come back anytime. There is not a lot to recap on HOA. In fact, the statute didn't change at all. The only changes that impact the HOA this year are changes under 468, which is the Community Association Management portion of the statutes. Is there a list of renters or other occupants and official record? If you are keeping a list, I would absolutely say that would be an official record of the association. Our board member emails public record when dealing with association business. So I wouldn't call them public record like under sunshine and government law, but board member emails are absolutely available. If you're doing official records requests, you're going to see them. And there's a reason why I'm quite sure AKAM and myself as an attorney, my whole team, make sure that we tell board members, don't use your personal email for board business, set up a new email. It's free, it's simple, but yeah, that's definitely available. Does the board have to sign all affidavits? Not necessarily. The board has to sign the SIRS affidavit. That's what I said. But the other affidavits can be signed by the person that's handling it on behalf of the board. So that affidavit for checking all of the emails to make sure that ballots came in, that could be your email administrator signing it. So it could be the person who's actually sending the notice of mailing in an election would sign the affidavit. But there are instances where the board is required, and that is one of them with structural integrity reserve studies. So if we have to approve minutes within days, do you have to have a meeting to do that? A meeting can be every month. So here's the thing, it's only approved, it's not forcing you to approve the meeting minutes. It's just saying what has to be up is only approved meeting minutes. So just keep doing it the way you're doing it, Dave, because that is normal. You will approve the meeting minutes at your next meeting. Do not create another meeting for it. Should credit card statements be posted online? They are not required to be on the website, but I will tell you it's something that people can request as part of the official records. Thank you for the great class. I appreciate that. Yes, you can get a YouTube link. Oh yeah, sure. You guys had a webinar yesterday, so Slovenon would like a YouTube link from yesterday's. And our board group text threads required to be disclosed. If you are conducting board business through a text thread, I'm going to tell you that they are absolutely going to request that, and you need to be very careful. We haven't seen any legislation dealing with messaging services, so the platforms on Facebook, WhatsApp, etc. But I've been telling board members not to use those mediums. And if they are going to use them with their friends, because just like the email list, right? Like, well, I've got a bunch of people and I want to tell them what I'm doing as a board member. I have them put a disclaimer on there that that's not official business of the association. And thank you for the thank yous. And we're ending right on time. All right, ladies. Any
Fantastic.
closing remarks?
No, I mean, I think this was a great call. I mean, very informative, a lot of tips on the things that our managers have to deal with on a very regular basis, as well as our board. So thank you.
Awesome.
Yeah.
Thank you, ladies.